Good afternoon, everyone. Welcome to our May in the Boardroom, where today we are going to be talking about Act 235, the Judicial Privacy Act. I'm Sarah Deidre Kasdorf, the Director of Outreach and Member Engagement for the Wisconsin Counties Association. I have the pleasure today of introducing this webinar and turning it over to our presenters. But before I do that, just a few quick comments. If you have questions throughout this webinar, please hit either the chat or the Q&A button on the bottom of your Zoom screen and type in your question or your comment. We will be checking the chat and the Q&A throughout the presentation. However, please keep in mind that if we do get a significant number of questions or if we start to fall behind, we may not get to every question as soon as it pops into the chat or Q&A, but we will have time following the presentation to get to all of the questions and comments that are raised by those participating in the webinar today. The other thing I'll just mention right up front as well is this webinar is being recorded, and the recording along with the PowerPoint presentation will be placed on the WCA website shortly after the conclusion of this webinar. With that, I am happy to introduce our presenters today for our In the Boardroom with attorney Andy Phillips in Attolles Law. Uh, Today, though, we do have a guest who is joining us for the presentation who is not a member of Attolles Law, but a very valued member of our county government family. So, as always, we have Andy Phillips with us from Attolles Law, but we have joining Andy today for this presentation Stacy Hoffman, who's the Jefferson County Register of Deeds, and Stacy also represents the Register of Deeds Association on the WCA Board of Directors. So, with that, I think I'm going to turn it over to Andy and Stacy at this point for our webinar.
Awesome. Thank you, Sarah. And hello, everybody. We're talking about an issue that we've talked about a lot over the last year, and that's Act 235, the Judicial Privacy Act. I think we've had now 4 or 5 different webinars devoted to Act 235, its interpretation, and more importantly, its implementation. I think Stacy and I have talked an awful lot about some of the challenges with implementation, and we are super excited to talk to everybody today about what we see as really, really good upgrades to Act 235 through some legislation that's been introduced and we hope will be acted upon quickly. So I guess if we're May 28, 2025, so that's our date marker here. If I can summarize the last 2 months, because we implemented this on April 1st, 2025, I think that we have seen less in terms of volume, in terms of judges that are requesting shielding than I had anticipated. And I also think that we have seen a number of questions that I wasn't anticipating. I mean, things like, hey, we sent this confidentiality agreement that's required by Act 235 out to ETF, State of Wisconsin, Department of Employee Trust Funds. And they said, we don't need to do that because we have our own privacy protection, so we refuse to sign. It was surprising to me because you know what? I thought that everybody at the state level and local level had an understanding what Act 235 did, and it exists independent of any other sort of confidentiality protections, and that we have to have this by law. We have to have this in order to implement. So again, that falls within the category of questions I wasn't anticipating. But Stacy, why don't you talk briefly about your much more boots on the ground, your experience with implementation since April 1st?
So it's been very slow, as you mentioned. I believe there's only 6 counties who have received a request so far. And from what I understand, the judicial officers are thinking it's a little hard for them to figure out where all their information is. So they're hoping with some of this cleanup legislation, it might help them out a little bit too.
Well, and I think too, we have to remember that judges are people and people often get confused by things. Judges don't deal with this issue, Act 235, all the time, even though they deal with all sorts of variety of legal issues all the time. And so I think it can be intimidating. It's certainly been intimidating to us, and we've had a year to digest this. So I understand part of the hesitation on the part of judges, but I think if we understand and appreciate the overall goal of Act 235, which is to keep judges as safe as possible. Hopefully, we can come up with implementation, we can come up with language, we can come up with procedures that will encourage judges to take advantage of the protections Act 235 provides and hopefully keep them as safe as possible. So, what do we want to talk about today? We're going to do four things. We're going to do a quick review of what the Judicial Privacy Act is. We're not going to go into detail. If you want to see detail on what Act 235 is, as I mentioned previously, Stacy and I have talked about this any number of times, and all of those presentations reside on WCA's website, wicounties.org, under past event materials. And that's the same place you're going to be able to find this discussion after it's downloaded as well. So go to wicounties.org if you want a refresher or a primer on what the Judicial Privacy Act does. Second, we're going to talk about some of the challenges that we have uncovered with implementation. These are challenges that we both anticipated and did not anticipate. We'll talk about those a little bit. Then we're going to talk about that trailer legislation I just mentioned, Assembly Bill 171, Senate Bill 169, what that legislation accomplishes and what we view Act 235 to look like after that trailer legislation is adopted. And then I want to touch on Act 126, which flew below the radar last legislative session, but provided similar protections, not the same breadth, but similar protections to election officials. So I want to talk about what Act 126 does. So again, let's just talk very basic terms. What is the Judicial Privacy Act? When we think about its genesis, it really flows from Daniel's Law, which was the federal counterpart to Act 235, and it essentially provided protection to federal judges and federal magistrate judges in the federal system, all right? Not state system, but in the federal system. And so if we look at what Act 235 does, it replicates in many respects what Daniel's Law does. That said, Act 235 extends far beyond what Daniel's Law does. It does that in a way of specifically targeting certain systems and certain records that are maintained at the state and local government level. And when we look at Act 235 and who is protected, there are categories of judicial officers that are protected. I want to make clear that part of the reason that that list exists is that all of them fall under the umbrella of the Director of State Courts office. And what I mean by that is that all of them organize their work, their occupation, so to speak, through the Director of State Courts, with the exception of municipal judges. All right, those are still city, village judges. And so I say all of this because right now, as Act 235 exists, we are working hand in glove with the Director of State Courts office on implementation, and we're working hand in glove with them on these legislative fixes that we want to see made. If the list of people entitled to protection extends to other occupations or categories of officials, we don't have the same relationship with the Director of State Courts because those people will not fall under the Director of State Courts umbrella. That's going to pose its own implementation challenges. Let me give you an example. Right now, if we have an issue with the form that judicial officers utilize in order to seek shielding, we go to the Director of State Courts office and say, have you thought about making this sort of change to your form? Director of State Courts may say, hey, you know what? Great idea. We'll make that change. That change then goes out to all of the judicial officers under Act 235. Again, if we have separate categories of officers or employees or occupations that are subject to protection, we're not going to have that same opportunity for a clearinghouse. And so that's the concern here when we talk about implementation of Act 235. We want to try as hard as we can to get it right now while we have the easy, if you will, opportunity for discussions with the umbrella organization that covers all of the judicial officers. And Stacy, I'm talking a lot, so if you want to jump in here,
No,
I
you
will
you
just keep
keep doing
rolling.
this. You're doing good. Thanks.
All right. So what information is subject to protection? Again, Act 235 has 9 categories of information that are subject to protection. And again, all of this ought to be near and dear to the heart of the people in counties that are responsible for implementation of Act 235. This is the information that cannot be disclosed. This is the information that is shielded. So we ought to know what information is subject here. What is not on this list?
A
Name.
name.
The name. We've had that question, Stacy. What
So
about a judicial officer's name? Well, I think that pretty much everybody knows or could easily find out who the judge is by name within a particular county. The name of a judge is not protected information. as we'll see later on as we talk about some of the challenges with implementation, sometimes judges have names that are common to other names. And so when we implement Act 235, we've got to make sure we're implementing on the right person. And that in and of itself can be a challenge. But I want to make it clear, name is not on the list of protected information. The request is valid for 10 years. And this is an issue that came up recently about what do we do about records or information that is created after a request for shielding comes in. It's going to be shielded. It's not a magic moment in time where everything that predates that request date gets redacted and everything that postdates that request date is unredacted. In other words, a judicial officer does not need to make daily requests for shielding. All right. It's a 10-year period where the clock starts ticking upon submission of the request. And for that 10-year period, all past information and information generated during that 10-year period is going to be subject to shielding. If you get to a point where a judicial officer re-ups the protection, so to speak. So let's say in 2025, we get a request from a judicial officer. We know that that request is going to expire in 2035. Let's say judicial officer submits another request in 2028. We re-up the 10-year period and that request for shielding goes out to 2038. So again, it's a long-term obligation on the part of the county and any other governmental agency to make sure that the appropriate information is shielded. There are exceptions to the exemption. And when we talk about exemption, that means that this personal information of a judicial officer is exempt from disclosure. There are exceptions to that exemption. And in Act 235, we have those exceptions identified if it's required in response to a court order. Second, if there is a consent. And third, if there is a consent on the part of the immediate family. Oh, I see. 2 is for the family and 3 is for the judicial officer, him or herself. So the important concept behind this consent feature is that we ran into all sorts of what if scenarios. What if neighbor of the judge needs to get information from Stacy in the Jefferson County Register of Deeds office in order to validate the existence of an easement or otherwise determine the boundaries of an easement, so on. How can we have access to that information so that we can do our job as title company, do our job as mortgage company, do our job as landowner, and so on. And consent is an important feature here because we always have the ability to ask the judicial officer, do you consent to the release of this information to XYZ person for purposes of ABC? You can always get that. And if we have that consent, there is never ever going to be a question of whether Stacy did her job as Register of Deeds to shield the information. So I don't know about you, Stacy, but I view the consent feature as very important in this entire equation.
It is important. Some of the questions that have come up with us, for instance, if a judicial officer asked to have their birth certificate shielded from public view, now he wants to come in and get a copy of his birth certificate or his child's, do they need to have a consent to release for us to issue that to them when we clearly know it is the judge themselves asking for their own record?
I think it's
I mean,
probably
by
good to
law,
have,
probably.
I think it's probably good to have some sort of form to document the fact that we verified that it was the judge making the request and that by making the request, the judge is consenting to that release of information to him or her. I think that's probably a best practice. But that brings up a very important point, Stacy. I bet you called corporation counsel, didn't you?
I did not yet.
Not
That
yet,
came
not
up. That
yet.
came up this
So
week. So
Danielle, that's coming, just so you're aware, if you're listening in, that's coming. But I think that if you have a question about the appropriate implementation, reach out to corporation counsel right away. I know personally, I've had several conversations with corporation counsel all over the state about implementation of Act 235, and they're the ones who are responsible for giving specific legal advice in a specific situation. So reach out to them. If you and your corp counsel are still finding yourself scratching your head saying, I don't know exactly how to interpret this or what we're going to do, reach out to WCA, and WCA will put you in contact with people like me or Stacy to say, has this issue come up before and how did you deal with it? And how can we have a common understanding of how to implement? And that's an important feature here is that as much as possible, From my perspective, I think from Stacy's perspective, we'd like to see 72 counties implementing in substantially similar ways, meaning that our interpretation of the law is common throughout Wisconsin. So if there's ever an issue that arises, it's all counties that are dealing with that issue, not one singular county. So again, go to your corporation counsel, and if you still find yourself with questions, reach out to WCA, reach out to Stacy, and we'll get this figured out. All right. A governmental agency, a county, is also permitted to provide access containing the personal information if a third party possesses a signed consent document, or if the information is subject to some of the financial institutions that are regulated under federal law, or there is an executed confidentiality agreement. All right. The confidentiality agreement, I spent a little time talking about this because there is no exemption under Act 235 for government to government transfer of information that's shielded under Act 235. All right, there's no exemption under current Act 235. And so the issue becomes whether we need a confidentiality agreement, for example, to send assessment information out to towns or cities and villages to the assessors so that they can do their job. And the answer is yes. Under Act 235, we interpret the current requirements to mean that we have to have an executed confidentiality agreement with the town, city, or village to ensure that they are not going to release that information out to the public, and that they understand that the information is subject to a shielding request by a judicial officer. So along those lines, I worked with corporation counsel and others to develop a template confidentiality agreement. Again, your corporation counsel is the expert. So speak to your corporation counsel about what form you should use for confidentiality agreements. But again, we pushed that template out in an effort to create uniformity across the state so that we could adequately implement this confidentiality agreement requirement and that we were all implementing on the same or similar terms. And so again, that confidentiality agreement becomes very important here. And we're going to talk further about the exceptions to the exemption when we get into the trailer legislation concept. But I'm just going to ask Stacy, real quick, how have you worked with confidentiality agreements thus far?
For the most part, I've just sent them out to all our title companies, and the ones that are smaller all agreed to it. The larger ones with a lot of attorneys have not agreed to them. So they won't be able to see the shielded record. We've had a few vendors who would like to have their own language added to the confidentiality agreement. We've had our corp counsel review it and agreed to it. For the most part, people are willing to sign if they don't have a lot of attorneys involved. Hate to say
Lawyers always mess things up. Is that the lesson that we're learning, Stacy?
Maybe, I don't know. Did you happen to notice that you're hard to hear?
Yeah, am I hard to hear? How are you hearing me now? Is it okay?
Yeah, Andy, I'm not having any trouble hearing you on my end. So,
Okay. So hopefully Sylvia can maybe adjust the volume and hopefully make it work a little bit better. But if you do find it hard to hear me, let me know because I'm not immune to technical issues. Heaven knows that. All right. Special rules for RODs. Stacy, you want to talk about this?
Sure. So the Register of Deeds have been very involved with this from the beginning. And we tried to get some clarification in the language right away before it became law. So for us, the judicial officer does have to identify the document numbers they would like us to shield. It's up to them to tell us which ones to shield. And then we are only shielding electronic images. So we don't have to burn a hole in a microfiche card. We don't have to rip a page out of a bound book. So for us, it's pretty nice and clear. Tell us the document number, we're going to shield that, and nobody's going to be able to see that.
And so I think this is important to keep in mind is that the special rules that apply to the Register of Deeds do not apply to everybody else. And the reason is because registers of deeds are super special and nice and we like them. Is that right, Stacy?
It's exactly why.
I think in reality, it's because you have mountains of information dealing with folks, both in written microfiche form and in electronic form. And so if we were to go and try to redact a 120-year-old plat book, or as you pointed out, burn a hole in microfiche, it wouldn't work that well. And
Right.
so recognizing some of the practical challenges with implementation of Act 235, the legislature was very smart to say we're going to create special rules for registers of deeds, which we're thankful for. I wanted to I know a couple of questions came in the chat related to confidentiality agreements. I want to address those because we just talked about it. Are confidentiality agreements being sent now before any judicial officer requests have even been received? Great question, Kathy. I know certain counties were proactive in sending out confidentiality agreements to vendors and others in an effort to try to get those on file so that when it came time to share information, they could do so with confidence and without having to scramble to get them in place. But I don't know, Stacy, have you heard about how prevalent is it that confidentiality agreements have been sent out?
It's a mix across the state. For instance, some counties, like you said, were very proactive. That way, if a judicial officer has something happening, want to buy a home, they want to take out a mortgage, it was set and ready to go. There's no time lag in it. Others felt that they should wait until they had a request. So it's half and half right now at this point.
I think the important point is it's okay to wait if that's what you'd rather do, because ultimately all Act 235 requires is you don't share that information until you have the confidentiality agreement. So it's no problem to wait if that's what you want to do. Next question from Bobby Joe. Would each member of the municipality need to sign a confidentiality agreement, or would one person representing the muni be able to sign? I think if we have an officer of the municipality with the authority to bind the municipality to the confidentiality agreement, sign that agreement, we're going to be just fine. We don't have to go to each and every person.
And there again, they probably should talk to their counsel, their legal counsel to make sure that that's how they want to handle it in their department.
Absolutely. Absolutely. There's a special rule not only for registers of deeds, but also rules relating to public-facing land records websites. And in this circumstance, we know that there is a conflict between Act 235's shielding requirement and the effort to promote the greatest amount of transparency as it relates to land records on a county website in an effort to serve the public. There's conflict there. And so what do we do with these public-facing land records websites where we have the general public accessing, typing up address, typing up name, getting all sorts of information about parcels of real property? It's utilized not only in the general public by a lot of professionals in the land record industry. So what do we do about this? Well, a public-facing land records website owner or operator is required to establish a process so that judicial officers and immediate family members can opt out from the display and search functions of their names. And this is important, and it's an important concept when we get to this trailer legislation of their names. So we're not going to eliminate access to all information, but we are going to eliminate search functionality on judicial officer name. Then once a display record comes back, we are obviously not going to tie judicial officer name to the particulars of a property. That personal information is protected, address is protected, so we're not going to tie that judicial officer's name to that particular address. This is something that I know several counties have done historically. Pre-Act 235 is they've allowed members of the public to opt out of the public display of their name on these public-facing land records websites. For example, the one that I always think of is Access Dane. That's a fantastic website that allows you to do all sorts of searches and get all sorts of information about properties. Dane County has provided a system for anybody desiring anonymity to submit a request that would avoid the public display of their name associated with a particular parcel of real property or address. So again, we implement based upon that historical practice that's happened in Dane County, and we tailor it to the information that a judicial officer requests shielding for. All right, so implementation challenges, and I've got a laundry list here, Stacy. And I think that we want to just go through and identify, and as much as I hate to do this, I'm just going to have you give a brief narrative of summary discussions that you've had with all of your colleagues and others involved with this effort to identify implementation challenges, because I know we've been meeting on this for, again, the better part of a year. So just give us a summary of some of the challenges that you've heard out there.
Well, without going through everyone on the list here, I'm not sure if that's what you want me to do, but so we'll just start with the first one. We were very concerned with somebody submitting a false request trying to hide their information if they're like going through a bankruptcy issue or a foreclosure type issue. So we wanted to make sure that these blank forms aren't out there for anyone to get. And I think Andy hit on this a little bit earlier, but it's the director of state courts are going to have these forms and they're going to be very specific who they hand them out to. So that's one thing that a lot of people are concerned with. And then we'll just go on. The Register of Deeds maintains paper records. Does Act 235 apply to those as well? The intent of the law was not to have that apply to our paper records. The judicial officers agreed that it was probably unlikely that somebody came into the courthouse to search through all our books and all our indexes. First of all, most people don't know how to do that, but they're going to go look on a computer. So if they look on a computer that's easily accessible, and that's how we decided we're going to shield just electronic records. And then if a judicial officer submits a request for shielding to one county office, does that constitute submission to all county offices? And Andy, we think it does.
We
right?
thought it does. And I mean, there were others out there that disagreed with us. And that's okay to disagree because Act 235 isn't clear. So it's not as though we were insisting upon a particular legal interpretation. But I think where we landed is it's better to be safe than sorry. And so let's implement in full across the county. In other words, if somebody submits a shielding request to you, Stacy, you're going to take that shielding request and talk to your corporation counsel or somebody else in Jefferson County to say, we got to get this out to all departments. That's the safest way to go to fully implement Act 235. And I think that was the advice that was pushed out to all counties across the state. But again, I don't think that that view was shared by the Director of State Court's office. And frankly, I don't think that view was shared necessarily by all corporation counsel across the state, which again is fine. But I think we were trying to err on the side of rather be safe than sorry.
So, and from that, if anything, you need to have a policy, right? How are you going to handle it within your county? Your county might be different than the other 71, but have a policy so everybody knows what to expect and the judge knows what to expect, right? When they submit something, if they know Jefferson County is going to share it across the county, they're maybe going to assume that the next county over is going to do the same, and that might not be the policy. So make sure you let the judicial officer know that if that's the case. Can a county or other government agency identify all records containing a judicial officer's personal information?
That's a tough one. That really is when it comes to implementation. I mean, I know, Stacy, you deal with an index. Not
Right.
all county departments or offices maintain indices of information. And so it's awfully difficult to search, retrieve, gather, whatever you want to call it, all records that apply to a judicial officer. And
So
so to your point, your earlier point, Stacy, policies, procedures, critically important so that people who do handle public records requests or interact with the public at the window, so to speak, requesting access to certain documents, they have an understanding of what shielding requests are out there and what does the shielding request require them to do before handing records or information over to somebody, whether it be by email, over the counter, whatever. Just make sure that everybody has an understanding of the obligations.
yeah, and you know, we don't always know where all the judge's information is. There's no way that the judge is going to know all that information is shared either. So it's going to be a hard one for people. So I think you just need to have that plan in place. So, does a government agency need confidentiality agreement to share with another government agency? At this moment, we say yes. And I think you hit a little bit on that before, Andy, also. We're hoping with some of the cleanup legislation that will change.
Yeah, that's right. But I mean, and it sounds almost silly that all we're doing is we're exercising our authority as government to do what the legislature has told us we have to do. We don't have a choice. So why is it that we would need a confidentiality agreement in place? Well, I think again, when Act 235 was drafted, it was an oversight, if you will. I think people recognize that government-to-government transfer of information might fall within an exception, which we're going to see in the trailer legislation in just a moment. But for right now, Act 235 requires those confidentiality agreements. And I think Laura from Sheboygan County had a great question here, as long as we're on the topic of confidentiality agreements. If we're talking about a confidentiality agreement, what's the expiration date on that agreement? I say never. I say as long as it's in force and nobody revokes. that confidentiality agreement is in place, meaning both sides have obligations under that agreement. And then the second follow-up question to that is consent document. Judicial officer consents to the release of information. Is that a forever consent on that information, or does that consent have a shelf life? Act 235 does not address that. But Stacy, do you have thoughts?
Yeah, so the act doesn't address it, but the consent form from the Director of State Courts does. It does offer them a few options. You could say it's a forever consent, or it is a limited time consent. So it would be up to the judicial officer to say how long they want that record open for somebody to view.
And Crystal from Sheboygan County just asked, where can we find the template confidentiality agreement? Crystal, if you wouldn't mind emailing me to remind me, I'll get you a copy of that right away. Next, what if a different statute requires publication of a judicial officer's personal information? And Stacy, this is where we heard a lot from our colleagues in the Treasurers Association saying, well, wait a second, the law requires us to publish certain information. So we either violate Act 235 or violate another statute. How do we choose which statute to violate?
Well, hopefully with cleanup legislation, we can get that straightened out.
I would agree. But
the way it's worded now, I think you can't post it or you can't publish it until
yeah,
we get that clarified.
And then you have due process issues that come into play as well. And so this is where I would tell you really, really consult with your corporation counsel, because depending upon the particular facts and circumstances, is there a workaround? Maybe, I don't know, but consult with your corporation counsel on that one. We talked about the land records website issue, and then we have a little bit of the remedies or penalties associated with non-compliance of Act 235. Stacey, I'm just going to ask you right now. You look at Act 235 and you say, you know what, it's a great idea, but I don't like it whatsoever. I'm not going to, in fact, I refuse to implement Act 235. What happens if somebody gets information from your office and it's a bad guy and bad guy harms a judge? What do you get charged with?
I am guilty of a Class G felony, which is 10 years in prison and $25,000 fine.
It's ugly. And frankly, I don't think we're going to have any counties and county officials that are ever subject to a prosecution for a felony for non-compliance with Act 235. I just don't think that's going to happen, because I think everybody I've talked to has said we want to do everything we can to keep judicial officers safe. Awesome. Question then becomes, all right, Act 235 creates what we call ministerial duties under the law. Ministerial meaning that we shall do something. We don't have discretion to apply the law as we best see fit. We have to do certain things under Act 235. Whenever we have a ministerial duty that's created under the law, we can be held responsible as counties and county officials for the negligent performance of that ministerial obligation. And so I didn't think it would be a good idea to open counties up to potential civil liability for negligent, again, not intentional, but negligent implementation of Act 235. So we wanted to address remedies in the context of this trailer legislation as well. So speaking of trailer legislation, let's talk a little bit about Assembly Bill 169 and Senate Bill 171. This is just a little bit of history as to how we got to this point. And so really want to thank Senator Wangard and Representative Tussler and their offices for their diligent work, working with a whole lot of different stakeholders to address a lot of the challenges and ambiguities that we found in Act 235. And so they have been on this since, I want to say, last October, November, and even before that time, they had reached out and said, look, what can we do to help? And so thank you very much to Senator Wangard and Representative Tussler for addressing this. And so in early April, we had the introduction of two bills, Senate Bill 169 and Assembly Bill 171, both the same bill, just introduced in each house of the legislature. Following introduction of those bills, there were several conversations with stakeholders, Director of State Courts, legislative offices, about issues that we saw in the legislation, because I don't care how well you instruct LRB to draft something, what comes back, you're going to think of something you weren't thinking about at the time you submitted it to LRB. LRB is the Legislative Reference Bureau. They're the ones who draft legislation. And so when we got those bills back, again, convened the stakeholder groups, had further discussions, and said, look, we need to update what it is that is contained within these two bills. And so that's where we had the concept of a substitute amendment come out. We had an Assembly substitute amendment and a Senate substitute amendment. What a substitute amendment to a bill is simply a replace the entirety of the bill with this over here. And so we had an entire replacement of the two bills with the substitute amendment. We got the substitute amendment back. And we said, we still have some challenges here. We still got some things that we need to tweak. And so we have amendments to the substitute amendment to the bills themselves. And so those amendments have been introduced now, and those amendments have gone through the process. We've actually had hearings in the Assembly Committee and in the Senate Committee to allow the public to provide their input as to Senate Bill 169 and Assembly Bill 171 related to, again, cleanup on Act 235. The legislature, every party who testified, every stakeholder understands that we want to get these issues fixed as quickly as possible because April 1 is right around the corner. I'm kidding. April 1 was last month.
God.
That's when we had to implement Act 235. And so there is a sense of urgency here to get this done. That said, I think that there is a strong desire to get this right. So we are not going to sacrifice good work product just for the sake of expediency. All right. We're going to try to get this right as best we can. But again, we understand the critical need to address these issues quickly.
And I'm just
So
going to mention,
go ahead, Stacey.
we're going to find, even after we've done all this and we thought we hit everything, we're going to find something else that we didn't even think about. So we
Guaranteed.
know there'll be continued amendments to this in the future, but this is a step in the right direction.
Well, and we found that out yesterday. It was yesterday that Stacy and I had the privilege of testifying before the Senate Committee on Senate Bill 171 relating to this fix. And it was at that hearing that we learned of an issue that we hadn't even thought of, and that related to implementation through the CCAP system and the Clerk of Circuit Court's inability to real-time update information after a request for shielding has come in. And so thankfully, that's not a county system issue. So we said, Director of State Courts, Clerk of Circuit Court, let's figure out how you can work with CCAP to get this implemented, but just let us know how it goes. And we're fully supportive of whatever it is that you all decide. But that's an example of an issue that arose that we hadn't even thought about. It arose just yesterday. And to your point, Stacy, I think we will see further issues arise in the future. So as we talked about, one of the issues that we had is that we have these forms that are out there. The Director of State Courts has kept these forms under lock and key, hasn't given us access to any of those forms. We, of course, see the forms when they come in, but they're not giving us access to the forms. Why? Because they don't want those forms out there so that bad guys who don't want to do good things wrongfully or fraudulently submit these forms. And so what the trailer legislation does is it enhances the protections on the form itself. First, it says that we have an exception under the public records law that says that we do not have the ability to grant access to any form blank or completed that is prescribed by the Director of State Courts. So we do not provide a requester under the public records law with the form either completed or in blank. Second, we have a requirement that the form be notarized. We want to make sure that whoever is submitting the form is indeed a judicial officer entitled to protection under Act 235. And then finally, we created a class of felonies. It's a Class H felony for somebody to intentionally submit false information or to submit a false consent form related to the protections under Act 235. So again, strengthened the protections associated with those forms, completed or blank. Clarifying the Register of Deeds obligation. Stacy, maybe you want to touch on this one.
So one of the questions that came up during all this is, so it says that in part of the statute that it's just the electronic records. Well, what about all our paper records? And because it didn't really specify that in there, people had questions whether it meant our paper recorded records. We had to come up, we had to shield, we had to pull the book off, we had to pull microfiche cards out. So this is just clarification what the intent of the bill was to do originally. This is going to clarify it's only going to be the electronic records of real estate recorded records. That was
and Stacy, we just had a question come in that I think is good. It relates to the previous point about these forms. Jamie asks, if we received a form submitted today, we wouldn't know what it looks like or what it should look like. We haven't seen it yet. How do we verify it? Your response?
Well, it's going to come on a form from the Director of State Courts, and it's a several page form. I think if we get a form, we have to take it and assume it's correct. Andy, do you
Uh,
have a better?
I, what I would say is, I don't think the Director of State Courts office would chastise anybody for calling them and saying, hey, by the way, we got this form. I just want to verify its authenticity. And I think asking those types of questions, I think is legitimate. Let's make sure that we implement appropriately. So speak with your corporation counsel, obviously, but then also if you have questions, reach out to the Director of State Courts office and ask them to see if they can assist in verifying authenticity.
That brings up a really good point, Andy. This is new for everybody, so don't be afraid to ask anyone questions. Don't be afraid to ask the judicial officer a question. Their personal information is going to be on there, so you can contact them and verify something, or if you have a question, contact them also. Contact the Director of State Courts. We're all in this together and trying to figure it out together. So
Absolutely. All right. So the other issue we had, remember that we said service or submission to one county office or department is service or submission to all county offices and departments. We said, you know what, that's the safe way to play this, but it'd be awfully nice if we as counties could designate a particular person or persons or office that would receive these requests. After all, if you look at, for example, the public records law, we know an authority, as defined under the public records law, has an obligation to maintain public records, but the authority also has the legal ability to designate a custodian of public records. We wanted the same type of system with Act 235. Why did we want this system? Well, number one, it's a good point of contact for all of these issues within a particular county. But number two, we can make sure that that person or persons have adequate training and procedures and policies in place to ensure that the request is treated appropriately. And so if you look at this trailer legislation, it creates 75707 sub 1 sub AM to define the term designated officer, and then it amends 75707 4B1A to provide that the request for shielding is submitted to the designated officer of a government agency. And again, I can't emphasize this enough. I think Stacy's in the same boat. She said it earlier. Let's do a lot of training and have policies and procedures in place so that we know that when a request comes in, we know what to do. Additional information on the records to be shielded. And this is again where we had, and I don't want to say conflict, but this is where we were a bit at odds with the Director of State Courts office. And what I mean by that is that as counties, we were sitting here saying, look, we don't know where all of this information resides. Could be in paper form, could be in electronic form. In most of our offices and departments, we don't have it indexed. It's not easily searchable. So it'd be really, really helpful if a judge could tell us what information they want shielded. Director of State Court's office came back, and I think it's a valid point. They said, how is a judge supposed to know what information is out there relating to this judge? You have mountains of information. How is it that the judge can identify what information needs to be shielded? He or she doesn't even know what you maintain. And so we reached what we think is a compromise, and that is that the judicial officer should identify with reasonable specificity the personal information to be protected. What we're getting at here is that there is certain information and records that a judge is going to know exists. If the judge applied for a change in zoning classification for his or her property, they know that the zoning office has information with their address on it. So make sure to put on the form, hey, check the zoning office. I know that's where that information is. That's all we wanted. At the same time, I think, again, speaking to policies, procedures, practices that we put in place, we want to have a process where the shielding request goes out and then people are trained on what to do with that shielding request. It should reside somewhere within an office or department so that whenever we get a third party requesting access to information, we double check that information and make sure that it does not contain information that is subject to a shielding request before we push it out to a member of the public. But again, this is one of the things that we wanted to see in the law that was a bit of a conflict with the Director of State Courts office, again, with good reason.
And I was just going to mention, Wisconsin Land Information Association did a really good paper on trying to triage these requests. You know, look at the ones that are very easily accessible to the public. Get those ones taken care of right away. I mean, we have 10 days to do them all, but get those ones taken care of right away. Then worry about the ones where somebody's going to have to come through and look through file cabinets and look through old paper documents to be able to find those. I think that's going to help you out a little bit and relieve some of your stress to try to triage that a little bit and just make sure you hit the ones that are really easily accessible to the public first and then go from there. So if anybody needs copies of that, I can help share that too.
We had a question about this slide, Stacy, from Melanie. So I'm going to put you on the hot seat here. Stacy, with the amendment addressing and applying to only electronic records, what happens if we have our vital records scanned into our repository? Are we okay if the repository is not accessible by the public?
So I would say if it's not accessible by the public, you're probably okay. But this is the forms of, or the original statute really applied to recorded real estate documents. So they're recorded documents, not filed birth certificates, that type of thing. But if you can have your repository not available to the public, you should be okay.
I would agree. All right, then we have this whole concept of transfer between government entities, and Laura had asked a follow-on question about whether we need a confidentiality agreement in place with municipalities and municipal assessors. Under Act 235, the answer is yes, we do. But this trailer legislation would allow for the transfer of information if the county, if they're the sending agency, provides receiving agency, in this circumstance, municipal assessor, with a written request for shielding, and the county notifies the judicial officer of the transfer of records. All right. So again, we have an obligation to let receiving agency know, hey, it's subject to a shielding request, and we have to let judicial officer know we sent this information out for this purpose. In that circumstance, we don't need a confidentiality agreement anymore. We can share government to government for a governmental purpose so long as we comply with those 2 points.
So Andy, can you maybe clarify a little bit? Because I know this has come up. So the assessors are not a government agency, right? They're private assessors.
So they would
The
be
municipality hires them.
They would be an agent to the municipality in that circumstance. Good point, Stacy. So once the records are transferred in compliance, and this was important from our standpoint, as we said, okay, from our point, our being county, if we send these records out and we let town, for example, know that there's a shielding request out there, if town later on messes up, that's not our responsibility. We can't become the Act 235 police for all of these other municipalities. So if everything happens according to, in this trailer legislation, what is allowed, we want the receiving agency, in my earlier example, the town, to have that primary obligation for Act 235 compliance. This whole conflict with other legal requirements, there is an exception baked into this trailer legislation that says if the release of the information is part of the publication of a notice, including a notice of an administrative hearing or appeal that is required by law, that is an exception to the Act 235 shielding requirements. It's important that in the context of this trailer legislation, not only is that a new exception, but we have a few others as well. First, title insurance companies and their agents, professional land surveyors, and licensed attorneys are now included within exceptions. Adjacent landowners seeking land records, they're included within the exception. And we also have an exception for compliance with the sex offender registration requirements. And so again, the trailer legislation creates additional exceptions that everybody felt comfortable creating, that it wasn't going to create too much of a problem in terms of the release of that information that would run contrary to the intent of Act 235. So those exceptions are contained within the trailer legislation. We talked about this briefly in the Access Dane example that I used, but with land records websites, the trailer legislation clarifies that is, so long as the search functionality based upon name is eliminated, that information that would otherwise be shielded can be accessed to a public land record website, so long as there is not a nexus or a tie-in between that information and the judicial officer's name. All right. So again, we wanted to make sure that it was clear that these public-facing land records websites were able to provide the functionality they currently provide, so long as we didn't disclose the judicial officer's name. And then we get into clarification on remedies. And what we tried to, the issue again was I didn't want to create a cottage industry for plaintiffs' lawyers to sue governmental entities for failure to adequately implement Act 235. And so the concern was, what are the remedies if somebody, a county, for example, fails to fully implement Act 235? Not a felony, but it's still not implementing. And we said, look, why don't we just replicate what the remedy is under the public records law? In other words, if a judicial officer thinks something ought to be shielded and county is not shielding it, judicial officer has the ability to go to court and ask the court for the remedy of mandamus, which is a directory order where the court simply says to the county, you have to shield this information. We put into the remedies section fee shifting, just like they have under the public records law, so that if judicial officer is successful in the mandamus claim, the county is on the hook for paying judicial officers legal fees. But the reason that that is there is, in my estimation, to force a conversation between judicial officer and county. And again, I don't see any county taking a position that says, I don't care what you say, Judge, I'm going to make your information public. That's not going to happen. There might be good faith disagreement about full implementation, but we ought to have that conversation about what it means. And I think for the most part, counties are going to err on the side of caution and overshield and not undershield. Again, I think there are going to be situations, hypotheticals, and circumstances that we're just not thinking of that we'll have to deal with in the coming days, weeks, months, and years. But for now, if we put into place the exclusive remedy of mandamus, similar to what's under the public records law, we're better off as counties because then we don't have to worry about civil liability. All right, we had a question from, I'm sorry, go ahead, Stacy.
I was just going to say, there's a question in there regarding a lot of zoning type things and meetings. Did you want to take a look at
Yeah,
that?
so the agendas for public meetings and things like that, those are still going to be subject to shielding. They are. If it is a required notice of a public hearing, for example, in other words, a statute requires that you publish a notice and that published notice contain the information that would otherwise be subject to shielding under the trailer legislation, that would be exempt from the shielding requirement. But again, we have to look at what is required by statute, not necessarily practice, not county ordinance, not resolution, but what is required by statute. And it's only in a circumstance where the publication with that information is required by statute that the exemption is going to apply. All right, so we've gone through the Act 235 information. We've got about 8 minutes left until we adjourn. So I'm going to quickly touch on this election official issue and then circle back and see if anybody has any follow-on questions related to Act 235. So Act 126 kind of flew under the radar last legislative session. We were all focused on Act 235, but Act 26, if you remember, that provision, that law essentially provided certain protections to election officials. And within that law was a provision that modified the public records law that says that an authority, for example, a county clerk, could not provide access to records containing personally identifiable information of an election official as defined in 5.024E or an election registration official as defined in 5.024G. I think we look at that terminology and we might say, well, that applies to county clerks, their deputies, municipal clerks, their deputies. What's the big deal? That's not a big deal. Well, take a look at how the statutes define an election official. It means any individual charged with any duties relating to the conduct of an election. That means if you had Grandpa come down and help out with registration on election day, Grandpa's an election official and automatically entitled to privacy protection. So then you sit there and you start saying, how in the world am I going to figure out who an election official is on any given day? And you mean that this applies to zoning office, sheriff's office, clerk's office, all of these different offices? How do we ever implement Act 126 in this regard? All right, so we identified the problem. Here's the fix. We've got Senate Bill 126, Assembly Bill 134 that has passed both houses of the legislature and is going to be presented to the governor. And what this essentially says is that a current or former election official or current or former election registration official, they're entitled to protection only if they submit a written request to the authority requesting that their information be kept confidential. So much like with Act 235, where a judge has to submit a request for shielding, An election official or election registration official has to submit a request for shielding with the authority. And remember, authority has a specific definition under the public records law. It's not just the county. The county itself is not the authority. It's the subunits within the county, the department, the office, the elected official, and so on. And so it's that authority that would receive the written request for confidentiality. And if that's the case, then I think we have to have a discussion again about policies, practices, to procedures to put in place to effectively implement the protections as it relates to these election officials. All right, as I mentioned, this legislation has been adopted. The amendment that would give us a bit more clarity and obviously a lot better understanding of our obligations. That's passed both houses of the legislature and it's awaiting the governor's action. We don't think the governor is going to veto this particular piece of legislation. There's always that chance, I guess, but we think it's more likely than not that this legislation will be signed. Among other reasons, aside from the cleanup that we wanted to see happen, there are specific deadlines within Act 126 that are coming up. July 1st, the big one, and there's no ability to implement by July 1st. So this legislation would push off the implementation deadline as well. All right, so with that, we are on to our Q&A period. We've got a couple of here. Mary asks on Act 126, what does the written request look like? The legislation doesn't say. So it could be handwritten on a note that says, I request that my information be shielded. Here's my name. Again, I think that we ought to have further discussion about implementation of Act 126. Frankly, I think that that's a discussion that starts with the clerks, because the clerks obviously are the chief election officials within a particular county. And so I think we ought to have a conversation with the clerks about effective implementation of Act 126 requirements. Ann asks, I'm still confused by the name being searchable. It's not a requirement for Act 235, but a judicial officer can opt out of their name being searchable. And what I want to make clear is the fact that you type somebody's name into a website in and of itself doesn't impact Act 235. It's the search result that comes back. Because if you type in, let's say I was a judge, Andy Phillips, you type in Andy Phillips in there, as soon as you type my name in the search function, that's not a problem. But as soon as that search function produces results and my name is tied to personal information, that's where we have an Act 235 concern. All right. So when we talk about functionality, what the trailer legislation clarifies is first, on the search function, it's not going to produce any records if you type in my name and I'm a judicial officer. There will be no result return. That's number one. Number two, if you type in 123 Main Street and I happen to live at 123 Main Street, the result that comes back is going to say occupant or current owner 123 Main Street. In other words, Andy Phillips as a judge is not going to be associated with a particular address. And so again, the fact that you type in somebody's name in a search bar, that doesn't do anything. It's not going to produce a record, but we want to make sure that there is no ability to go through the back door and find out that person's name just simply by entering an address.
And we should clarify, Andy, that that's only for land records websites. It's not for every website. It's not.
That's a good point.
CCAP or child support lien docket or those type of things.
Okay, Jamie asked a question. This is a question for you, Stacy. Can you see it in chat before I repeat it? It has to do with the indices and document number for RODs, because this is a particular point, because I think Jamie might be confused, because when we talk about the particular rules for registers of deeds, there is a requirement that they identify by document numbers. Do you want to talk about that for a moment?
So I'm trying to read through it real quick. I know that the judicial officer is going to come to you and say, hey, I don't know what all my document numbers are. I think we have an obligation to show them how to use our system and let them search it, or have them hire a title company or have a staff member come down and look at it. I don't feel that we should be giving them the document numbers that they should be shielding. Is that where we're going with this?
Yeah, I mean, do we have an obligation to help them to find the document number? Legally, probably not, but humanly, probably.
Sure.
I mean, as a human being, are we going to help the judge identify the document numbers, help them with the index system, help them with the search functionality to say this is how you find it?
Yeah, I think we would do that like we would do any other person that came into our office for any search. But for us to fill out the form for them with these are the exact document numbers you should be doing, I wouldn't do that because what if we missed one or I don't know.
Yeah, I wouldn't do that. At the same time, I think that helping them to understand the functionality so that they can find the information, I think that's
Exactly.
something
We
we
should be
ought to
helping.
do. Yeah, Susan asked a good point to your point, Stacy. In case of helping a judicial officer and one was missed, who's liable? Great question. I mean, honestly, we get back to this whole remedy issue and it becomes a mandamus issue. Um, I'd hate to have something happen like this and have harm come to a judicial officer because of something missed, but that's the danger. It really is. And so you want to be helpful without assuming full responsibility, if that makes sense.
Yeah, we can't give legal advice, but we answer all the legal questions, those kind of things.
Funny how that works. All right, we are at the appointed hour, 1 o'clock. So we'll leave this open for just a moment and see if there are any other questions that come in here. Oops.
There's a Bobby Joe says their tax program is creating false name and addresses when you search a parcel. I have concerns over this. What are your thoughts? So I think what happens, Andy, is there's a specific program that says, okay, instead of being Stacy Hoffman, now it comes up with Jonathan Smith or something like it just creates a fake name in the system.
I don't like that because
I don't either.
I
But
would
I
rather it
know,
be current owner or occupant, something like that. I don't like the false name thing. I mean, here's the issue though. As soon as you put current owner, that information pops up on the screen. If you're a bad guy, what are you going to think?
yeah, it's got to be somebody I'm trying to
Oh,
hide.
I think a judge lives there.
Yeah.
And so that's kind of, when we talk about these implementation challenges and issues, that's kind of an example of what we're going to be facing. All right, Sarah, did you want to pop back on camera and round this out with any comments that you might have about this?
I did. Another question popped into the chat though, so I didn't know if you wanted to address that first.
Oh, the one from Eric or from
Yes,
Deb?
the one from Eric and now one just popped in from Deb as well.
Yeah, I know. I mean, Eric's point is well taken. It goes both ways. If the judge says the search and access to shield all documents, you're likely to get shielding requests for documents related to the parcels the judge no longer owns. Yeah, great point. I
Yeah.
think we're going to have challenges like this along the way. Now, the trailer legislation does limit it to 3 addresses that a judge can protect, primary and 2 secondary residences. But is there a check in there to verify the judge actually owns or spends 14 or more days at that secondary address? No. Do we have an obligation to verify that information? No. So we just implement according to what the form says. I mean, any other thoughts, Stace?
I was saying, and the trailer legislation also requires them to notify us within 90 days of that no longer being their address. So
And we know judges never forget, so they'll
you
always
know it's
remember.
going to happen.
It's going to be a challenge. Um, Deb asked, should software providers exclude the search for current owner? I mean, potentially, I don't know how the software works in your particular situation, Deb, but I think you ought to work with the provider to find out what's the best way to implement. I would prefer that a search for current owner does not produce an address list, frankly. All right, Sarah, I think we're through. Oh, Susan has a question. Curious to know if there's any more chatter about expansions. It'd be nice to know if this is moving into other professions and when. Stacy, how many professions does this apply to in Florida?
I think it's 126, 126 here.
126. So we have, I think it's 7 categories right now in Wisconsin, and Florida's at 126. If we look at movement nationwide, there is movement to include others in the list. We know in Wisconsin, in Governor Evers' budget, he had a movement, or not a movement, a proposal to include federal judges and magistrate judges in the protected categories under Act 235. So it's going to expand. I don't know when. I think it will expand. I think that's inevitable. And as I mentioned at the beginning, that's going to create its own implementation issues that we're going to have to deal with.
All right. So thank you very much, Stacy and Andy. If anybody else has any questions, feel free to reach out to the WCA office. Marcy Rainbolt on our staff is the point person, but you can reach out to any member of our staff and we will work with Andy and Stacy to get you an answer. So with that, again, great conversation today. We had over 200 individuals join us for this particular in the boardroom, which is quite a few more than what we typically see with our standard in the boardroom series. So great topic, great discussion, lots
I
of good
wouldn't, Sarah,
information.
I wouldn't repeat that too much. Stacy's going to think it's because of her.
Well, I'm pretty sure it is.
Just be careful. All
Well, we know
right.
it's not you, Andy, because
I know it's not
everyone.
me.
So it has to be Stacy, right?
I like the way you guys think.
All right. All right. So again, if you want to review this webinar, it will be placed on the WCA website, wicounties.org. On the upper right corner of the homepage, all you have to do is click on the button called WCA Webinars, and you will be taken to the page where this webinar recording, along with the PowerPoint presentation, will be housed. Just a quick shout out for our June in the boardroom. Andy, we're going to talk about one of our favorite issues, topic we just, I think, talked with two counties last week, which is building a foundation of good ethics and avoiding conflict of interest.
Yeah, and it's a topic that I know it's not sexy. I'm not going to claim it is sexy, but it is very, very confusing, and it's oftentimes misapplied. People talk about conduct issues as though they were ethics issues as though they were conduct issues, and then nobody seems to recognize the very important implications of 946.13, which makes it a felony to engage in certain conflict of interest transactions. So we're going to go through that in a bit more detail to give everybody a solid foundation and understanding of ethics and conflicts of interest as it applies to officials in county government.
Andy, you just used the F word on our
And the F word,
on
I
our
know.
webinar today. I was thinking
Right.
maybe you were going to talk about the dreaded F word and leave it as a cliffhanger for next month. But
Well,
again,
how many people remember that next month, right?
that's right. What is the dreaded F word when we're talking about these topics? So with that, I want to thank everybody for joining us today. Thanks Stacy and Andy for this for all of this great information. Again, will be posted on the WCA website. Have a good rest of your day, and we'll see everybody back here on June 25th.
Thank you.
Thanks.